and if there is, I will set a bond. Everything you say is being recorded, so you don't have to tell me about your case, because today is not your trial, and it is not the day to discuss your case. It's only to figure out if there's probable cause and set a bond. You do have a right to an attorney. If you can't afford one, one could be appointed. That would be the public defender, who will be there to help you. And if he's not, there will be one here to talk to you over the microphone. If you do have any questions, please feel free to ask. But once again, everything is being recorded, so you need to watch out what you say. Let's go to the first case. That would be LaShonda White. LaShonda White? Can they hear me? Oh, there she is. Okay. Miss White, you have been charged with trespassing. I do find probable cause. Does she have any priors?
Your Honor, she had like petty theft, 2 petty thefts in this year.
Okay, then I will keep the bond at $25.
Judge, and speaking of Ms. White, I'm sorry, I apologize, I didn't hear what was going on. She wishes to ask the court if you could consider resolving this case today for a time, sir.
State, do you have any offer on this case?
Your Honor, the state's offer, and good morning, Your Honor, Jessica Butler on behalf of the state. The state's offer would be a withhold of adjudication, court costs, and no return to the address of 124060 Northwest 15th Street, 601 in Sunrise, Florida. It's the Palms at Sawgrass Mills, Your Honor.
Did you wish to resolve it?
Do you wish to accept the court's offer?
Yes.
Okay.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Judge, we're having a hard time hearing you. The volume is really low. I don't know if there's any way to raise it.
Your Honor, yesterday they had the issue that tech people came down here and
Okay, I just did raise the volume. Is that better?
It helped a little bit, Judge. Not perfect, but it helped a little bit.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Do you understand English?
Yes.
How far did you go in school?
College, graduated.
Do you understand the charge?
Yes.
Do you wish to plead no contest?
Yes.
Okay. Do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea. I'll sentence you to a withhold court costs, no return. Have a good day.
Thank you.
Judy Callahan.
She's in North Broward, Judge.
Okay, I have here a violation of probation. You have a hearing date set for June 22nd. There's a no bond hold on that.
Judge, I don't know if Ms. Callahan might be interested in resolving this case this morning. If the court could consider a withheld adjudication, she wouldn't lose her license for a year. But I don't know if she'd be interested in that or...
Brian, it's a VOP.
Oh, it's a VOP.
Yes.
Oh, I thought it was a capias. Okay. All right. Sorry,
It's
Judy.
a violation of probation. It's a no bond hold. You have a hearing date set on June 22nd. Good luck to you, ma'am.
Thank you.
Thank you. I have Martina Soto. Martina Soto.
Should be in jail.
Martina Soto is coming up, Judge?
Okay, you have been charged, or you have a violation of probation as well. You have a capias for $1,500 and another one for $250. You have a hearing date set for June 29th at 10 a.m.
All right, thank you.
Thank you.
Your Honor, I received a call from the jail requesting a couple of cases to be taken out of turn, if you would consider it.
I would.
On page 7, Calvin Thomas. I know you don't have page numbers, but if you keep going, it's there's Jones, Randall, Cologne, and then Thomas. Hey, good morning.
What's the name?
Thomas, I think.
Calvin Thomas.
Calvin Thomas, who else?
Yeah, okay. Let's do one at a time. Well, you could tell her the other names.
Is
Mr. Calvin Thomas is here present, Judge.
Okay, Mr. Thomas, do you have a capias?
Isaac Mathis on 28.
You have a capias of $500.
Judge, Mr. Thomas is asking if your court will consider resolving the case today.
Okay, State, did you have an offer?
Just one moment, Your Honor. I want to take a look at the priors. If you just put the CCN from 108,429. Yes, and then just go to reports, case reports. Yeah.
Possession of paraphernalia, Your Honor, 2017 out of Palm Beach, petty theft, and resisting without violence, 2016.
Do you have an offer?
Your Honor, the seats offers an adjudication court costs and any credit for time served.
He wishes to accept the court's offer.
Sir, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Do you understand English?
Yes.
How far did you go in school?
Graduation.
12th grade? Did you finish 12th grade?
Yes.
Okay. Do you wish to enter a plea of no contest?
Yes.
Okay, I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea and I'll sentence you to an adjudication court cost. Good luck to you. What's the next case?
I believe the other one was it Isaac Mathis?
Credit for whatever he served. I don't. Doesn't matter.
Hello?
Was the other one Isaac Mathis? Okay.
What page
Isaac
is it?
Mathis.
Page
Page 28.
Mr. Mathis, Isaac
Correct, the
Mathis,
post Miranda.
Wait.
come on up.
So, and I think that you sent it to Alexis.
Mr. Mathis is here present at main judge.
I'm relaxed.
Oh, it's only on a disc. Okay. Okay, well, I think in the PC it does.
What page is Mathis on?
He's on page 28, Judge. Towards the very end of the docket.
Sorry, was she good? Yeah, she's good. What case are we addressing? I'm sorry. Which one are we on? Mathis?
Okay, we have Isaac Mathis. It's a violation of probation with a no bond hold and a grand theft. I find probable cause on the grand theft, and I would set bond at $1,000. Okay? Thank you.
Good luck, sir.
Yes, sir. What case did you have?
Good morning, Your Honor.
That was it.
Hey, Mr. Romero, how are you? Good morning.
Good morning, Mr. McCall.
Thank you. Judge, on page, I think the pages have changed a little bit, but on page 8, there's Samantha Johnson. She's over in North Broward. She's here on the City of Fort Lauderdale Municipal Ordinance Trespass.
Page what?
I don't know how to tell the pages. They keep. It was on page 8. It's
Samantha
changed.
Johnson?
Sorry, Your Honor.
Is that what you said, Samantha Johnson?
I did. She's actually on page 1 at North Broward.
Page 1.
Wait. No.
That's a different Johnson.
Is it Daranique Johnson? Is page?
No, it's right out. Two more.
So on page 2, Judge.
I see it. Okay, she's in North Broward. North Broward. Okay.
This is Samantha Johnson.
Yes, that's the correct one. Thank you very much. Okay, we have, she has a status set in Division MH at 6/20/17 at 9 a.m. She has a capias bond of $250.
Judge, I was hoping that we could try to see if we could resolve this matter. It's a simple trespass at the Winn-Dixie on Cordova Road.
Oh,
And I already had time served, and I paid for that, so I shouldn't have a warrant.
Okay, I don't know any of her priors or anything.
March of this year,
And I had a
trespass.
warrant that I didn't know about.
Okay, 1 minute, ma'am.
Is it the same trespass?
No, this was, she had
No.
a guilty from March of this year. She,
It was a different location.
another municipal ordinance case, 2016, a trespass, 2016 guilty, defrauding an innkeeper, 2015, and another petty theft, 2015.
Judge, all minor offenses, Your Honor. She's only had one other offense this year.
And how many days does she have in?
I just got here later.
She would have 1 day, Judge, but unless she has other time when she claims that she's been in on this.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do, yes.
Do you understand English?
Yes.
How far did you go in school?
College graduate.
Do you understand the charge?
Well, I really didn't do anything, so it's kind of a funky charge, let alone I don't know, I didn't know I had a warrant. I was
Okay,
just
the
sitting-
charge is a trespass.
Yes, I know.
If you want to plead not guilty and have a trial and have your day in court, you can do that. If you want to plead no contest, then you can do that and we'll resolve it today. What would you like to do?
Resolve it right now.
Okay. How do you wish to plead? Guilty, not guilty, or no contest?
No contest.
Do you have any questions for your attorney?
Will we waive everything because I had already served for the warrant?
I'm going to adjudicate you guilty. You're going to have court costs of $293.
I think it's actually $78, Judge, if I'm not mistaken, at the magistrates, if she resolves at the magistrates.
Okay, your court, I'm going to send you to court costs, and you will also have a no return order to that location. Do you understand?
Yes.
I'll sentence you to an adjudication court cost. No return. Okay, good luck to you.
Okay. And
you,
then
Judge.
everything else will be taken care of.
I don't know what everything else is, but you will
This is the
be,
only thing holding you. You will be released.
Okay. Thank you.
Take care.
thank you.
Thank you.
Did you have any others?
Yes, Your Honor. There are two more on page, three more on page 8 of the docket. There's a Schneider Valcine. He's also in North Broward.
Okay, I got him. Yeah, I've reviewed this. I do find probable cause. Is he there?
He's en route, Your Honor. We have him come as they're on the docket, but you pulled him early.
Yeah, we
He's
did.
already in walking distance.
We did pull him early. Sorry to
Yeah,
inconvenience you.
He's on his way. He'll be here within 3 minutes.
Okay. Can we do something else instead?
Yes, Judge. There's Russell Newby, Judge. He's in the main jail, and he's here on a 2016 case.
About where is he in the docket?
Down where you were, three cases after, 2 cases after where you were.
Okay. So, do they change the dockets from the morning, from when they email them? Is that what? Okay. I have different pages, yeah.
Russell Newby, main jail. He has a capias for $100, and he's in Division MP on June 26 at 1:30.
Right, Judge, this is a 2016 capias. I've represented Mr. Newby several times. I think last time I represented him, he was going into one of the facilities to get some assistance. So at the time I represented him, Judge, he was homeless. More than likely, he didn't get notice of the court date and he missed court. It's an alcoholic beverage municipal ordinance violation. Is there any way we could resolve it today, Judge?
Would you like to resolve your case today?
Yes, sir, Your Honor.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Do you understand English?
Yes, sir.
Do you understand the charge?
Yes, sir, I do.
Do you wish to enter a plea of no contest?
I do, sir.
Okay, I find you've made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to an adjudication court case. Good luck to you.
Yes, sir.
Okay.
Judge, on the next page, Judge, maybe 1, 2, 3 people down is Bonnie Anthony,
Bonnie Anthony, come on up, please.
and he's also in the main jail, Judge.
Okay.
He's here approaching, Judge.
Okay, what were you looking at this?
Judge, he's got 2 separate municipal ordinance cases. He's got this new one, which is an alcohol violation and littering, and he has an old one, which is alcoholic beverage, Judge, and we were hoping to resolve this matter as well.
Okay, and this is his third one?
He has 2, Judge. He has 2 on the docket today. They're both for the same offense. It's basically open container.
Did you want to resolve your case today?
Yes.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Do you understand English?
Yes.
How far did you go in school?
11.
Do you understand the charge?
Yes.
Do you wish to enter a plea of no contest?
Yes.
I find you've made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to an adjudication court cost time, sir.
Okay, thank you.
Thank
All
you. Yeah. Thank you. Going back to Valson. Is that your last one?
Yes, Judge. Judge, you trying to get rid of me?
Huh?
Trying to get rid of me, Your Honor?
No?
I'm only joking, Judge.
I just was going to ask if you had another one.
Just levity, Judge.
I'm not used to that. He's not here yet, but I'm not planning to resolve this one.
I didn't think so, Judge. I see that there's it's
violent.
Right. So. Judge, what I will ask, Your Honor, is if the court would order a mental health evaluation to be performed at North Broward, and if this case be sent to Judge Wren.
Okay. I will order a mental health evaluation. I'll send at North Broward, and I'll send to Judge Lerner Wren. Are you aware if he has any assets of any kind?
I'm not, Judge.
My guess is he doesn't, but
it's a $25 bond, Judge, so that's my guess as well.
Okay, Mr. Valson, you have 3 charges, municipal ordinance violations. I found probable cause, and I am going to set bond on $25 on each count. Okay. Have a good day. Thank you very much. Okay, getting back to the order. Daronique Johnson. Okay, Ms. Johnson, you have been charged. You have 2 outstanding capiases. One is a no bond hold, and one is $500. And
there's the same case number on both of them. I want to know, how did I catch this warrant if I just came out of the hospital from suffering from kidney stones and a bad UTI?
Okay, well, you can handle that in the division that it was set in with the judge in that division. And
excuse me, count 2 is correct that it should be a violation of pretrial warrant.
Okay, count 2 was a violation of your pretrial.
Yes, sir. I've been calling my pretrial caseworker and telling her I'm in the hospital. I've been spending days in the hospital.
Okay, you could take that up with the division, and I wish you luck and have a good day. Kashyla Martin.
What do you mean by the legal?
Kashyla Martin.
I believe she's in North Broward, Judge.
Yeah. Yeah, I'm waiting.
Said right now, good.
One moment, she's in a wheelchair.
Thank you.
Hi, Miss Martin. You have been charged with, a while back, with a driving with your license suspended. You have an outstanding capias, and that was for an amount of $250. Okay?
Judge, she doesn't have anything else holding her. I don't know if Miss Martin might be interested in resolving this case this morning. Would you be interested in that? Miss Martin, would you?
If
Okay.
you do, I just want you to understand that once you are sentenced 3 times within a 5-year period to driving with your license suspended, your license will be habitualized. Do you understand that?
Yes, sir.
Okay, I'm trying to look for your driving record.
Martin.
I don't know what kind of order are these in?
We're just, I wanted to see her driving record on like our system because
What
it's just.
kind of order are these driving?
Perfect.
Driving on an ID card.
State, did you have an offer in the case?
I'm about to review the driving record now, Your Honor.
Yeah, I can't see it, so if you could tell me how many she has, that would be appreciated.
Sure. Your Honor, it looks like from 2015 and 2016, she only has no valid driver's license. I don't see any prior driving while license suspended on the driving record. I don't know if she has any other outstanding,
Okay, I
but
do see that too.
per the record. So the state's offer would be an adjudication, court costs, and credit for time served.
Do you want to resolve the matter?
Yes, sir.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Do you understand English?
Yes, sir.
How far did you go in school?
12th grade.
Do you understand the charge?
Yes, sir.
Do you wish to enter a plea of no contest?
Yes, sir.
Do you understand you have a right to an attorney, and do you waive that right?
Yes, sir.
Are you under the influence of drugs, alcohol, any other substance, or do you suffer from any mental illness?
Yes, I had 2 That's why I'm in a wheelchair.
Is that going to impair your ability to understand what you're doing here today?
No, sir.
And has anyone threatened you, coerced you, or promised you anything to get you to make the plea?
No, sir.
And do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
And do you understand that this plea will serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender? Do you understand?
Yes, sir.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea. Based on the documents in the file, I find a factual basis for the plea. I'll sentence you to an adjudication court cost. Good luck to you.
Thank you.
Thank you. Dina Schufelt.
Judge, I've been advised she bonded.
Patricia Caruso.
She's here present at main, Judge. She's approaching.
We skipped one.
And I have a deadline writing.
Okay. You have been charged with a touch or strike battery. I do find probable cause. Counsel, did you have any argument?
Not in reference to probable cause. I don't know if my colleague does, but in speaking with Ms. Caruso, she informed me she's 64 years old. Unfortunately, she was married. Her husband passed away. She's a widow. Her only source of income, Judge, she collects disability. She gets approximately $650 per month. My understanding is in the 64 years, I believe she has one prior, which was in 1983, I believe it's DUI. 1982. Judge, she's got very limited income. She owns no property, no money in the bank. Judge, considering her financial situation, she did inform me she suffers from health problems. I'd be asking you at this time to consider a standard pretrial for Ms. Caruso.
Any objection?
Your Honor, I do feel that the bond for this case is appropriate, but I just would ask that if she is released to a pretrial, that there be no contact with the victim.
Okay, I'm going to do the standard bond of $1,000. No contact, direct or indirect, with the victim. You cannot go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even go by the victim. If you need to get anything from the property, please have someone else go for you. Thank you.
Judge, so it's not pretrial?
I didn't order pretrial.
Thank you, Judge.
Sandy Green.
Ms. Green is at the Paul Ryan facility.
Okay. You have an outstanding capias for $1,000. It's already set before the judge on 6/20/2017 at 8:30 a.m. Okay, good luck to you. Carlexis Lurie.
Ms. Laurie's here at Manger. She's approaching.
Okay, she has a felony violation of probation with a no bond hold. It's set for 6/20/2017.
Good luck, then.
Good luck, ma'am. Nante Chandel Williams.
We'd waive formal reading of the charges, Your Honor.
She's approaching, Judge.
Okay, the formal reading was waived. State, do you have any priors on Ms. Chandel?
Your Honor, she does not have any prior history.
Okay.
Judge, in speaking with Ms. Williams, as the state confirmed, this is her first exposure to the criminal justice system. She's 21 years old. At this time, she's enrolled in Broward College. She's set to start this fall. She's a graduate of Plantation High School, class of 2015. She lives in Hunt Sunrise with her boyfriend. She does have family that resides in our community. Her aunt is the person that she's going to count on, along with her boyfriend, to potentially help post her bond. Her aunt is a stay-at-home wife, so unfortunately, Ms. Williams doesn't know her aunt's financial resources in order to post her bond. I'd ask you to consider basically her lack of any priors as far as in the criminal justice system and imposing a reasonable bond on Ms. Williams' behalf, Judge.
Okay. State, did you have a recommendation?
Your Honor, based on the seriousness of the facts of the case, I would ask for $50,000 on each count. If she is going to be released, I would ask for a pretrial release with the GPS monitor and no contact with the victim.
Judge, respectfully, $50,000 on each count. My math is correct. That'd be $300,000. That is tantamount to no bond, particularly for Ms. Williams. What I'd ask you to consider is $5,000 each count. That would make it a total of $30,000. That still is probably out of range for her aunt and her boyfriend, but that's something at least they could strive for.
Okay, I'm going to set this at $10,000 each count. I am going to require pretrial if she does get released. And there will be no victim contact, direct or indirect, with the victim. You cannot go with within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get any clothing or property from the premises, please have someone else go for you. I also am going to require an ankle monitor.
Thank you, Judge.
Thank you. Kathleen, Michelle, Michael.
Ms. McKell is approaching, Judge.
Okay. You have two hearing dates for felony violation of probation. One is on 6/20/17 at 9:45 a.m. The other is 6/21/17 at 8:30 a.m. They're all no bond holds, all your violations of probation. I do find probable cause, and was there a recommendation on the other counts?
Judge, the defense would be fine with the standard bond currently in place. I believe $1,000 count 4, no bond necessary on count 1, and then 7, considering she's being held no bond.
On count 7, I'll just do a $500 bond. Okay, and the rest will be no bond holds. Thank you. Mayor. Okay, Miss Mayor, you are charged with possession of heroin. State, do you have any priors?
Ms. Mayor, Your Honor, she had a 2017, excuse me, possession of cocaine and possession of heroin. I see it's not filed yet. Also, false ID to a Leo, 2015. Possession of PVP, 2015. Cocaine, drug paraphernalia.
Do you have any objection to the standard bond on this count?
Can you give me an ROR, sir? I don't have it in my bond.
Your Honor, I don't have an objection to the standard bond.
Okay, counsel.
Judge, Miss Mayer indicated to me that she would like to see if the court would consider pretrial release in her case.
She has an open case.
ROR. I don't have any
filed,
on
but she does have a pending case.
Okay. No, I'm going to require her to have a bond of $1,000. That's the standard bond on it. She has priors, and hopefully this will work out for her. Lamoy Wallace. Good morning, Ms. Wallace. You've been charged with aggravated battery with a deadly weapon. State, does she have any priors?
2012 domestic violence battery out of date that was went to pre-trial diversion program.
That's it? And did you have a recommendation for the amount?
Your Honor, the state's recommendation would be $5,000.
Okay. Counsel?
And no contact with the victim, Your Honor.
Judge, in speaking Ms. Wallace, as I believe the state confirmed, I don't think she has no prior convictions, Judge. She's been residing in our community since 2009. She's 26 years old. She is currently employed. She works for a company called Global Response and Customer Service. She's making approximately $12 an hour. She lives in Lauderdale Lakes. She rents her own apartment. $800 a month is her rent. She's going to be calling her father to help post her bond. What we're going to be requesting is a phone order in order for her to get the contact number of her father. She informed me that her father does not have much financial resources to bond out. What we'd be respectfully asking is for you to consider a $2,000 bond on Ms. Wallace's behalf.
And I would add, Judge, not to defend anything in the allegation, but this is a pretty short and lacking in a lot of detail probable cause affidavit. We don't really know exactly what happened here. This could be a mutual combat situation. It could be a lot of different things. It's only like one paragraph long.
Yes, and I also saw the weapon, what it was. So
no, I understand that.
It wasn't a gun. It wasn't a knife.
No, it's a stick.
Yeah. So I will reduce the recommendation from the state to $2,500. There will also be pretrial when she gets out. No victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even go by the victim. Thank you.
Is that with an electronic monitor?
No monitors necessary on this. What?
And will you sign an order, Judge?
Yes.
Yes, I'm drafting an order to give her access to her phone. Is that what you wanted?
Yes, Mr. Reed.
Okay, Lynn Sergala.
North Broward.
Okay, I see that you were charged with an aggravated assault with a deadly weapon and resisting without violence.
No.
I'm
a kidnapped victim. I was kidnapped.
Okay,
from my
Miss,
apartment.
I understand that
Dr.
you're
Segala,
going to be allowed to deny the charges. Today is not the day to do that. So if you put...
I'm a kidnapped victim. I was not arrested. There was no arrest procedure. I was kidnapped by two thugs, Justice police officers, and I stepped out of our little golf apartment.
You do understand I advised you not to talk about the facts of your case, correct?
I am a kidnapped victim. I was not arrested. There was no arrest procedure. I was kidnapped by two thugs. I was injured.
Okay, I find probable cause. Does she have any priors?
No, Your Honor.
And did you have a recommendation for a bond?
I don't have an arrest now. I was not
Yes,
arrested.
Your
I
Honor,
was
the
kidnapped.
state's recommendation was $5,000.
Okay, and counsel, do you have any recommendation? Okay.
I was kidnapped.
Okay, I'm going to set bond.
There was no arrest procedure.
I'm going to set bond at $5,000 on count 1 and on count 2. I am not going to, it's going
My
to be,
husband and my son are out of the country.
it
now.
will be $500. Thank you. Good luck to you, ma'am.
I was kidnapped without any proof. My purse.
Samira Miranda.
Identification.
Judge, Ms. Miranda, I've been advised bonded.
Okay. Nahum Osceola.
I've been advised, Ms. Osceola bonded, Judge.
Yvette Arias.
North Broward.
No, they just got bonded. There wasn't a determination or anything.
North Broward, Yvette Arias.
That's where she is.
All right. Arias.
Okay. Hi, Miss Arias. You've been charged with an aggravated assault with a deadly weapon without intent, touch or strike battery. State, do you have an offer or a recommendation and priors?
Your Honor, she does have a lengthy prior record. 2002 aggravated assault with a deadly weapon. She received a withhold of adjudication. 2005 DUI adjudication. 2005 battery on a law enforcement officer adjudication. 2005 simple battery adjudication. 2006 battery withhold.
Don't say anything.
2007 aggravated battery on a pregnant victim. The charge was null crossed. 2008 DUI adjudication. 2008 DUI with property damage adjudication. 2008 battery on a law enforcement officer. Trespass and disorderly conduct adjudication. The defendant failed to appear during the pendency of that case. 2010 out of Del Rey. I see a disorderly intoxication and theft adjudication. 2011 domestic battery.
I don't mean to cut you off, but do you have a recommendation?
Your Honor, the state's recommendation based on prior history would be $15,000.
That's going to be tantamount to no bond to her, Judge.
Did you ask her if she has a job and all those? Did you want to talk to
She
me
does
about-
not. She has some issues. We were hoping that there would be a place called Blue Waters that she could stay at, but apparently that's not going to happen. My main concern is that she has a dog that's in her apartment.
Does she have any assets or anything
She has nothing,
like that?
Judge.
Yes.
Do you have any assets?
I have a lot of stuff in the room that I rent, and I have a puppy that.
How much is your rent?
How much is your rent of it?
$860.
Okay. Do you have any family or friends?
I only had Tiffany by Blue Water who would accept me with a dog.
Miss, you're not listening to me. I understand you want to tell me things, but you have to listen to my question. Do you have any family or friends?
Yeah, but I don't know their phone numbers, sir, without my cell phone.
Okay. Do you have if I release your phone, can you call them?
I was arrested in my pajamas. I don't have even my cell phone with me, sir.
Okay.
And I go back to work on the 1st.
What do you do for a living?
I'm a health insurance agent.
Okay. I'm going to set bond on count 1 at $5,000. Count 2
Sir,
is
I don't have any money to
$1,000.
bring
I'll let the public defender, he can contact you and try to find your friends and family so we could help your dog.
Judge, I'm going to ask you to sign an order allowing our office to take photographs of Ms. Arias.
Granted.
Order me to a recovery place, sir.
I don't have a recovery place to send you to. I can allow you to go to SAP if you would like to go to that program. Your program, you're going to have to speak to your lawyer, and your lawyer will be able to help you with that issue. Okay?
You'll allow me to go to SAP?
Yes.
Can I take that now?
So I'll draft an order allowing you into SAP.
Okay. Good luck to you, ma'am. Johnny Jones.
Mr. Jones is here present, Judge? At Maine?
Okay, he has two capiases. One is.
Judge,
Go ahead.
they're both municipal ordinances, so we don't represent him, but my understanding, Judge, as a friend of the court, he was being held on another charge. He's been in custody 11 months. From what he advised me, he resolved this case. He was sentenced to House of Hope. So on his other charges, he's currently pending placement in House of Hope. So I just wanted to advise the court that. And I believe Mr. Jones is going to ask you if you can resolve the case.
Okay,
that is correct, Judge.
I'm not going to resolve the case because there's restitution involved in this. But he can take that up with the court in the division he's required to go to.
Judge, in that.
And these are add-on charges also, 4 and 5. Count 4 and 5.
Judge, I know this
He's
is not
already
a-
resolved counts 1 and 2, and he's been ordered to House of Hope on those other charges. So the only thing holding him in jail and the only thing preventing him from going to House of Hope are these 2 municipal ordinance charges. Is that your understanding, Mr. Romero?
Okay, I'd like to take care of it, but he owes money, and I
I
don't.
understand, Judge.
Can't you get this heard right away in the division? It's a misdemeanor.
There's only so much we can do. It's not a misdemeanor. It's a municipal ordinance, so we really don't represent him
Well-
on these.
Okay, so you can't do anything.
We'll
And I believe, Judge, looking at the case number, I can be wrong, it's a 40A, so I believe they're out of a satellite courtroom. So, I mean, DSO isn't going to transport him, and maybe that's why he missed court. I know he's probably eventually going to be transported to the main courthouse, but I don't know if that had anything to do for the reason why the original capias was issued.
Go ahead.
It was issued while he was in custody because we do not transport to the satellite location.
Considering those circumstances, would you ROR then?
Well, if I ROR him, will he be able to come to court?
Well, he'll be at House of Hope,
Will and
right? You'll be at House of Hope, Mr. Jones, right?
Correct. Yes.
Yes, sir.
okay, will you show up?
Yes, sir.
I'll ROR him.
Thank you, Judge.
Cedric Randall.
Mr. Randall, come on up, please.
Okay, sir, you are charged. You actually have 2 no bond capiases. You're both set on 6/20/17 at 9 a.m.
Good luck, sir.
Dejan Frazier.
Mr. Frazier, come on up, please.
You've been charged with operating a motor vehicle without a license.
Judge, Mr. Frazier is inquiring if Your Honor would consider resolving his case today.
State, you have an offer?
Looking for the part. Just one moment, please.
When you're not talking, you have to press the button because you're so loud. It's not you, but it's the courtroom itself. It's so loud I can't hear.
Your Honor, the state's offered be an adjudication, court costs, and credit for time served.
Would he like to do that?
He wishes to accept the court's offer. Let the judge know.
I will accept, Your Honor.
Okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Do you understand English?
Yes, sir.
How far did you go in school?
12th grade.
Do you understand the charges?
Yes, sir.
Do you wish to enter a plea of no contest?
Yes, sir.
I am looking at the Department of Motor Vehicle form. I want to advise you I don't see any driving with your license suspended. Do you understand that?
Yes, sir.
Do you understand that this plea will serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender? Do you understand? And do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
And do you understand you have a right to an attorney, and do you waive that right?
Yes, sir.
Okay. I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea. I'll sentence you to an adjudication court cost. Okay. Timothy Powell. Timothy Powell?
Yes, sir. North Broward, Your Honor.
Okay, State, did you have an offer on this case? It's an operating without a valid license.
Your Honor, the state's offered be an adjudication, court costs, and credit for time served.
Okay, I've reviewed there's a capias outstanding, so there's probable cause. If you'd like to resolve this case, I'll do that. It's an adjudication, court costs. What would you like to do?
Dissolve it, sir.
Okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Do you understand English?
Yes, sir.
How far did you go in school?
I think that.
Do you understand the charge?
Yes, sir.
Do you wish to enter a plea of no contest?
No contest, sir.
Okay, do you understand you have a right to an attorney, and do you waive that right?
Yes, sir.
Do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
And also, do you understand the plea will serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender?
Yes, sir.
Okay. I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and based on the documents in the file, I find a factual basis for the plea, and I'll sentence you to an adjudication court cost. And and also, I want to just put on the record, I've reviewed your driving record, and this would be the first driving with your license suspended within this 5-year period. Thank you very much, and have a good day.
Okay, thank you, sir.
Yes.
Good morning, Judge. Cynthia Honick on behalf of the Office of Statewide Prosecution regarding the case of Solomon Walker. I'm trying to find his page number.
Is it in the beginning or the end?
Towards the end. He'll be on page 18. Looks like more.
It's more like the middle, actually, Judge.
Yeah, it's like the front of what we've gotten done. Okay. Is he here?
He's here at Maine, Judge.
Solomon Walker. 1 count of racketeering. Counts 2 through 8 are trafficking oxycodone. Count 17, I'm sorry, jumping ahead maybe. Counts 9 through 16. 9 and 10 are trafficking oxycodone. 11 through 16 is trafficking morphine. 17 through 21, or 17 through 19 is trafficking morphine. 20 is obtaining controlled substance by fraud. Count 21 is fraud, impersonating the use of another with an ID. Okay, and I see what the standard bond is. Is that what you're requesting?
Judge, actually, a judge signed the arrest warrant, and the judge issued the bond amounts as well as the conditions of bond, including the FBI. And that judge was Judge Dennis Bailey.
Yes, I saw that. I've read that.
Yes, we're exactly requesting that.
Counsel, did you want to say something?
Judge, in reference to Mr. Walker, I did speak to him briefly about the charges that he's being charged with and the bond amounts. After speaking with Mr. Walker, my understanding is he's been residing in South Florida his whole life. He's 63 years old. He's on disability. He gets approximately $800 a month. He lives in Fort Lauderdale. He's been residing in the same location for about 4 years. He does have family that lives in Broward County in our community. His sister, uncle, nephews. His sister, I believe, works for Bayview Cadillac in the parts department. That's who he's going to be contacting to help post his bond. So financially, what the bonds are currently set at is out of his financial possibilities. My understanding is, in his priors, if the state can confirm, I believe he had one prior incident about 10 years ago. So I'd be asking you at this time to consider reducing the bonds that are currently set in place, at least particularly on count 1 from the $100,000 that's currently set to $10,000 on count 1, Judge.
Judge, Unfortunately, I don't have his criminal history in front of me. However, considering the nature of the activity and the conspiracy itself, the fact that he's charged with 11 other co-defendants, I'd be asking you to keep the bond the same amount.
Okay, I am going to find probable cause. I've reviewed the warrant signed by Judge Bailey. I'm going to keep the bond at $100,000 on count 1. Counts 2 through 10 will be $10,000. Counts 11 through 19 will be that $7,500. Count 20 will be $5,000, and count 21 will be $1,000. Thank you very much, and good luck to you, based on the nature of the crime and the warrant. Okay? Yes, absolutely. Okay, William Beaver. You need something? William Beaver?
North Broward, Judge.
Was he shot during this?
No, sir.
Yeah, reading the probable cause affidavit, I didn't see that.
William Beaver.
Yeah, I don't think they're slow because of that. Yeah. Okay, Mr. Beaver, you were charged with criminal mischief. I read the probable cause affidavit. I do find probable cause. The standard bond is $25.
Judge, I don't know if Mr. Beaver might be inclined to try and resolve this morning.
If he's in on something else, he might not want to.
Are you in on something else, Mr. Beaver? Is this the only charge holding you?
Yes, sir.
Would you like to resolve the case, or do you want to post a $25 bond?
I'll resolve it, sir.
And I don't feel comfortable giving an offer on this matter because it is a case where there could be restitution. There's a victim in the case, and I just haven't had an opportunity to contact.
Yeah, and I do believe he might have something pending. So
I have nothing pending, sir.
I'm not going to argue with you about it, and I do believe that there's restitution involved, and I'm just going to keep bond at $25. Thank you. Good luck to you.
And no contact with the victim, please, Your Honor. There's a victim in the case.
No return. Is that what you would prefer?
No, I would prefer just no contact.
It was a criminal mischief.
Anybody going to bond you out, William?
Right. It was his
Anybody I can call for you?
ex-girlfriend's vehicle.
I have no family, no nothing. Everybody moved to Virginia.
Where are you living?
Like renting by myself.
Where would you be living if you were released?
I'm staying with a friend.
Okay, no victim contact as well. Okay, good luck to you, sir. Josh Bryant. I get you in a minute.
Here, Judge Maine. He's approaching. Mr. Bryant, come on up, please. And he informed me he's going to be bonding out, Judge.
Okay. I do find probable cause, and I'll set the bond at $100. I won't change it.
Thank you, Judge.
Thank you. Counsel?
Good morning, Your Honor. I was advised to appear before Your Honor because it's something that's not printing on calendar, but it's an issue with the inmate bonding system. My name's Adam Goodman. I represent the client who had a case that stemmed out of Miramar yesterday, and they arrested him in Miami Gardens. They created a Miami-Dade case. Long and short, there's a hold from someone in Broward. And even Miramar Police Department is like, we shouldn't be holding, and Miami can't release a hold because they have no jurisdiction over Miramar. And I don't know where else to go. And this is where we were told to go by basically everybody.
Okay, well, I don't even know what the case is, so.
I have the paperwork from Miramar, and I have the case from Miami-Dade. I have the docket that shows that he did bond out in Miami. Just Miami will not release him, and I was basically told I have to come to Broward, but they don't have. BSO didn't have anything on it. I don't really know what to do. Someone's being illegally detained at this point.
He's in Dade, they won't release him.
Because
And
of a
where's he supposed to go?
Well, Miramar said they placed a hold on him, but basically Miami and Miramar charged him for the exact same crime. No different. It's the exact. Even the PC is copied from Miramar.
So there's no case in Broward?
It's supposed to be a Broward case because it was Miramar police that
Does
arrested
it have
him.
a case number?
It has a police case number. I don't think it has a case number over here yet, but I need some sort of judge, and I can't go to any judge, and there's no prosecutor assigned, and
Yeah, you have to probably go to a duty judge. If I'm looking into it. I don't know.
yeah, but I would still need a prosecutor because I can't just like show up to a duty
Have
judge.
you talked to a prosecutor?
Because there's no one assigned. So if this was the only place where there's just kind of arbitrary, everyone else is like, it's not my division, it's not my problem.
Well, I would never say it's not my problem, but it,
Yeah.
you know, I'm sympathetic to your point, but you might want to talk to a supervisor at the state attorney, because if they file a case or charge something, that's how it all starts.
Duty prosecutors.
Okay, I'll try to get the information from one of these prosecutors.
I'm going to be here for a while, so you could come back and talk to me, and I'll be here at 1:30 as well. So
Okay,
I'm not trying to
No, I
push you
understand.
off, but I need something before I can do something.
It's a super interesting legal issue, absent the fact that someone's in jail. But that's besides the point. So, okay, I'll try to get the information from these prosecutors and see. And I have to go to an investiture this afternoon, but I'll be done by then. So if I have to come back, I'll come back.
All right.
Thank you, Your Honor.
Thank you. Winston St. Jean.
Mr. St. Jean is present here at Maine. He's approaching, Judge. He informed me he's bonding out.
Okay, he does have a capias of $500. I won't change it.
Thank you, Judge. Good luck, sir. Thank you.
Wisely Veeb.
Mr. Vivi? Mr. Vivi, come on up, please. He's here at Maine, Judge.
Okay, he has two capiases. One's 250 and one's an ROR.
Correct. Judge, Mr. Vivi is asking if the court would consider resolving his cases today.
Okay, one's a petty theft and one's a trespass. Do you have an offer?
If you just one moment, Your Honor, I'm going to pull up this PC just to make sure there's not any restitution on the petty theft.
This is the third petty theft.
Okay. Okay. So, Your Honor, my offer would be an adjudication, court costs, 10 days in Broward County Jail with any credit for time served, and no return to that location. And that is based on his prior history, Your Honor. And it's the Coles at 6950 State Road 7 in Coconut Creek. Can you pull up the trespass case?
Same case.
Oh, it's the same
Judge,
case. And count two would be.
Vivi has advised me that he wishes to resolve the case, but he's asking he needs to be out in order to take care of some affairs he has.
He could either resolve the case, it's 10 days, or he could have a $250 bond, whatever he chooses.
Let me ask him. Let the judge know what you want to do.
Good afternoon, Your Honor.
Do you wish to accept the judge's offer or the court's offer?
With 10 days and with yes, sir.
It's an adjudication, court costs 10 days, no return to Coles, or you could, I do find probable cause or capiases, it's $250.
Your Honor, I'm sorry, I forgot count two. That would just be an adjudication court cost.
What did you want to do?
I'd like to resolve the case.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Do you understand English?
Yes, sir.
How far did you go in school?
I graduated at 12th grade.
Do you understand the charge?
Yes, sir.
Do you wish to enter a plea of no contest?
Yes, sir, I would.
Do you understand you have a right to an attorney, and do you waive that right?
I do.
Are you under the influence of drugs, alcohol, any other substance, or do you suffer from any mental illness?
Yes, sir. Just anxiety and asthma.
And does any of that impair your ability to understand what you're doing here today?
Not at all, sir.
Has anyone threatened you, coerced you, or promised you anything to get you to make the plea?
No, sir.
Do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes, sir. I'm a citizen.
Okay, good. And do you understand this plea will serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender?
Yes, sir. I understand.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea. Based on the documents, I find a factual basis for the plea. I'll sentence you on count 1, adjudication court costs 10 days jail, no return to the coals. Count 2, adjudication court costs. Good luck to you.
Okay, thanks.
Thank you. Christopher Wint. Christopher Wint.
I've been advised he bonded, Judge.
George Cruson.
Mr. Cruison's here present, Judge. He's defined to serve as public defender.
Okay, Mr. Cruson, you were charged with a DUI, an operating motor vehicle without license, and possession of cannabis. I find probable cause. State any priors?
2009 petty theft. WLS 2008.
99 DUI adjudication. Possession of cocaine adjudicated also in 99. A DUI adjudicated in 96. Another in 95.
Okay, sir, do you have a job?
Yes, sir.
What do you do for a living?
I repair copy machines.
Okay, how long have you been doing that?
A long time.
Okay, there's a lot of time, a year, 5 years, 10 years?
25 years.
Okay, that's a lot of time. And do you have any assets? A home, car, anything like that?
Scooter. Motor scooter.
I'm going to set bond on count 1 based on the priors. I have $5,000. Count 2, an ROR. Count 3, $100. Good luck to you, sir.
Is this something we could resolve today? Your Honor?
No, it's not that type of case that you could resolve today. It's a DUI. Good luck to you. Dustin Heron.
Mr. Heron is here present, Judge.
Okay, sir, you've been charged with a criminal mischief and loitering and prowling. I find probable cause. Counsel, did you have anything to argue?
I know it's a criminal mischief, Judge. I know this isn't the type of charge that can be resolved here at magistrates. He did tell me he was here visiting friends. He's from Okeechobee. I know that's he has his mom that he could help, that he could contact to help post his bond, but it's going to be a long distance phone number. I don't know, how soon he's going to be able to have access to be able to make a long distance phone number call. Rather, would you entertain an ROR on count 1?
State?
Your Honor, I'm fine with the standard bond. I think that is appropriate in this.
Does he have priors?
What is the?
Yeah, he has a possession of drug paraphernalia 2015 out of St. Lucie County. Also, Your Honor, 2015 he had a DUI conviction with a possession of cannabis.
Okay, I'm gonna ROR count 2, but I'm gonna keep the bond at $25 on count 1.
Thank you.
Thank you.
Hold on, Judge, could you give me 5 seconds?
Does
to
he
get
need
the
his
number
phone?
of his mom?
Does he need his phone? Okay, you have his number. Okay, that's fine. Wesley Calixte.
Mr. Collection.
Okay, he has a capias outstanding for $2,500 on a possession 2,000. For it says 2,500 for possession of drug paraphernalia.
Judge, Mr. Colexi is inquiring concerning this 2013 case. Would you consider resolving his case today?
State, do you have an offer?
Your Honor, the state's offer is a withhold court costs.
Withhold court costs. If you wish to accept it today, you could. If you don't, you can contest the charges, fight it. You could bond up for $25. What would you like to do, sir?
Okay, so if I resolve it, will I be out today?
We can hear you.
Oh, I'm sorry. Judge, he wishes to accept the court's offer.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Do you understand English?
Yes, sir.
How far did you go in school?
High school.
Do you,
High school graduate, 12th grade.
do you understand the charge?
Yes, ma'am.
Do you wish to enter a plea of no contest?
Yes, ma'am. Yes, sir.
Do you understand you have a right to an attorney, and do you waive that right?
Yes, sir.
Are you under the influence of drugs, alcohol, any other substance, or do you suffer from any mental illness?
No, sir.
Has anyone threatened you, coerced you, or promised you anything to get you to make the plea?
No, sir.
And do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
And do you understand the plea will serve as a basis for your license being suspended, revoked, or you being declared a habitual traffic offender?
Yes, sir.
I find you made a knowing, intelligent, and voluntary waiver of your rights, including your right to an attorney. I accept your plea, and I'll sentence you to a withhold court cost. Good luck to you.
All right, thank you.
Terrence Peterson. Hi, sir. How you doing today?
Not too good, sir, but thank you.
Okay. You've been charged with possession of a forged bank bill and fraud. State, what are the priors?
Well, this is count 4 and 5.
Yeah, it's an add-on.
So the count 1 is a possession of cannabis over 20 grams, possession of THC, and possession of drug paraphernalia.
Okay, did he have any other priors? Counsel, did you have any argument on his behalf?
Not at this time, Your Honor.
Okay, I will set bond at $1,000 on count 4 and 5.
Mr.
Okay.
Judge,
Yes, sir.
I'm from Las Vegas. I'm not from here. I've been here for 2 days now. I would like you to see if I could please go to my property and get a phone number for my mom, so at least I can call her and let her know that I'm here, and someone else may possibly pay my bill, because I've been here. No one knows I'm here. I'm not from this state. And I just want to let my family know that I'm here, or someone to try to help me out.
Mr. Reedy,
If the judge signs an order granting you access to your property, will you be able to get a phone number and call somebody?
Yes, sir, I would.
Okay, I'll draft that order for you.
I'll sign it.
Thank you.
Okay, thank you. Good luck, Mr. Peterson.
Thank you so much.
And Enode Duversey.
Your Honor, count 19 was corrected. It should be convenience instead of obstruction.
What are you telling me? It says
I'm sorry.
burglary, unoccupied structure.
Yes, it was corrected. It should be convenience. Count 19, just count 19.
Is that why I'm here, is just on count 19?
No, Your Honor, I believe it's for all of the charges,
Well,
12.
because there's add-ons, yeah, 12.
Yeah. All the add-on charges.
Okay, sir, you have been charged with an add-on count. Counts 12 through 15 are burglary. Count 16 is grand theft. 17 is petty theft. 18 is illegal use. 19 is burglary of an unoccupied structure, unoccupied conveyance. Count 20 is petty theft. Count 21 through 24 is burglary. Count 25 is illegal use. Count 26 and 27 are petty thefts. Counts 28 petty theft, 29 burglary, count 30 grand theft, count 31 illegal use of a credit card, count 32 license plates, possession counterfeit, count 33 resisting without violence, count 34 fleeing and eluding, count 35 reckless driving, count 36 driving with your license suspended, count 37 failing to stop, count 38 operating without a valid license, and count 39 attaching a registration. I find probable cause.
And Your Honor, the officer is here on the case. I believe that he wants to speak about the case to you when you're ready.
Okay, are you requesting the convenience bonds?
Your Honor, I would like to see what the officer has to say regarding the case, but based on the other counts 1 was a grand theft, 2 was a possession of cocaine, 3 was a resisting, 4 is a burglary, 5 is a grand theft.
What's the total bond on all of those?
The previous ones?
That would be easier.
The total bond. Just add them up. It's okay. We'll add it up right now for you, Your Honor.
Officer, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. State your name and spell your last name for the record.
Detective Juan here as well, Hierrezuelo.
Okay. Do you need to tell me something?
Basically, I'm just here representing the Broward Sheriff's Office and our charges in this case. There are other agencies that are either charging Mr. Devese with some other cases involving some other criminal investigations, and there's some investigations that are still currently active. We'd just like to see Your Honor impose the highest bond possible to keep him incarcerated. That's what I'm here for. That's the only reason I'm here, sir.
Okay. Counsel for the defense, would you like to say something?
Yes, Judge. And speaking with Mr. Diversey, as you know, he's already been magistrate on counts 1 through 11. He's still in custody, so the bonds that are currently set, they're financially kind of out of his reach. He lives in Fort Lauderdale. He lives with his grandmother. His grandmother is the only person that could maybe potentially help him post bond, but she's on a fixed income. She gets housing and Social Security, so she has very limited funds. He personally has no money in bank, no property. He's been residing in South Florida for about 25 years. From what he advised me, Judge, he works at a restaurant called Bahia Cabana. He's a cook. He's been employed there for about 2 years, making basically minimum wage. What I'd be asking you to do, Judge, is considering his financial resources, I would ask you to set a reasonable bonds on the remaining counts, 12 through 15. I would ask you to set at $1,500 each count. And I would ask you on 19, same thing, 1,500. 21 and 22, I would ask you to set 1,500. 23, 24, 29, same thing, Judge.
And Your Honor, for count 12, for the burglary counts, count 12 through 15, the state would be asking for $10,000 on each count. He does have about $30,000 right now. To answer your question, that he was being held on, it was $29,700. For the grand theft, I would ask for a $1,000 bond. For the petty theft, $100. On count 18, the state would ask for $1,000. On count 19, the state would ask for $10,000. On count 20, the 20 petty theft, the state would ask for a $100 bond. For 21 and 22, the burglary count, the state would ask for $10,000, and that $10,000 on 23 and 24. $1,000 for the illegal use of credit card, and $100 bonds on the petty thefts in 26 through 28, Your Honor. 29, 10,000 for the burglary, and for the remaining counts, the state would ask for, well, $1,000 on the grand theft counts, Your Honor, and the fleeing and eluding, and the convenience bonds on the misdemeanor, Your Honor.
That's tantamount to no bond, Judge. He's already got a $20,000 bond on count 4.
He already has 30,000, and he hasn't
Right.
gotten out. So
Yeah.
even if I said $1, it'd be tantamount to no bond.
We would agree to a $1 bond, Your Honor.
Yeah, I would think so, but I'm gonna pick a fair bond for each count. So I'll start 12 through 16 will be 5,000 each. Count 16 is 1,000. Count 17 is $25. Count 18 is 1,000. Count 19 will be 5,000. Let me. Count 21 will be 5,000. Count 22, 23, 24 will be 5,000. Count 26 is 1,000. Count 26 is 25. Count 27 is 25. Count 28 is 25. Count 29, I'll do 1,500. Count 31 through 32, 31 and 32 and 33 are 1,000. The 33 is 100. Count 34 is 1,000. Count 35 is 100. Count 36 is 100. Count 37 is an ROR. Count 38 and 39 are $25.
And Your Honor, I apologize. I missed count 19 for burglary. Was that
5,000.
5,000? And Your Honor, the state would just ask that if he is able to bond out, that he be released to pretrial with an ankle monitor
Granted.
and no contact with any of the victims.
Thank you, Your Honor.
Count 1
Thank
through
you.
11 on pretrial?
Thank you, State.
Okay, Charles Fields.
Charles Field, he's in regular court? Judge, I've been advised he's in regular court.
Isn't every court regular?
You are correct.
Some courts are rather irregular, actually.
So I don't need to make a finding of probable cause?
It should be reset, Judge.
Okay. Sorry.
Wangel Benoit. This one was reset, Wang?
Benoit is here present, Judge. How do you pronounce your last name? Benoit.
Okay, Wangel Benoit. You have been charged with a violation of community control with a no bond hold. You have a hearing set for June 20th at 8:30. Good luck to you.
June 20th, let's see you got to that. Mr. Smith, Russell Smith?
Russell Smith.
Is he here?
Smith.
Are you guys waiting for something? I'll take you next. I just thought you were. Okay, Russell Smith, you have a violation of probation. You have a no bond hold, and the hearing's June 20th at 8:30.
June 20th, you'll see your judge. Good luck.
Thank you very much. Do you want to come up and call your case?
Page 26, Andy Williams.
And are you waiting for a lawyer or something?
We're detectives for Hollywood Police Department.
I knew you looked familiar.
Williams.
Andy Williams. Okay. All right. Andy Williams. Andy Williams.
He's here on main, Judge. What page is Mr. Williams on?
26.
Page 26?
Okay, 1 second. He does have a felony violation of probation set for June 20th at 8:45 a.m.
Excuse me, Your Honor, that one was corrected. Count 18 is out of Madison County, and for count 19, I have been advised that that is no longer probation on that case.
Okay, so 19 is no longer here.
Well, that's separate, but still, the PO.
Okay, and 18, what about 18? That's a no bond hold for Madison County?
Yes, not problem.
Okay. All right, sir, you have been charged with counts 1 through 8, possession of a weapon or ammo by convicted felon. Counts 9 through 12, possession of a weapon or ammo by convicted felon. Counts 13 and 14, delivery of heroin. Count 15, trafficking in heroin, 4 grams or less. Count 16, possession of amphetamine. Count 17, resisting without violence. Count 18, probation violation with a no bond hold. And as you heard, count 19 is a probation violation with a no bond hold, but that was removed. Okay. State, did you have a recommendation?
Your Honor, he was serving a house arrest with an ankle monitor at the time that this offense occurred. That arrest was for, I believe, drug charges.
Felony delivery with a firearm.
Yes, Your Honor. So he was already on house arrest for felony delivery of a firearm when this offense was committed. For count 1, I'd ask for $5,000. Count 2, $5,000. Count 3, $5,000. Count 4 through 12, I would ask for $5,000 on each of the counts with the possession of weapon or ammo by a convicted felon. On counts 13 and 14, Your Honor, I would ask for $50,000. And on counts 15, I would like the bond to remain at, I would like the bond to be $100,000. Count 16, $5,000, and count 17 can remain the $100 bond, Your Honor.
Okay, counsel, did you have an argument?
I have a question, actually. How many weapons were recovered, Detective?
2 firearms, 1 stolen that was loaded with 10 bullets.
Okay, so basically these charges are 1 charge for each bullet. Is that correct?
Right.
Yeah, Judge, I'd ask you to ROR Mr. Williams on all but 2 of the possession of a weapon charges. Charging him per bullet is redundant and not necessary. As to the other charges, I understand the state's position. He's got a no bond hold in any event. I don't know if Mr. Romero has anything to add.
Okay.
Judge, in reference to his financial situation, Judge, I know he's 28 years old. At this time, he's unemployed. I know he has no money in the bank. So I ask you to consider that in determining a reasonable bond on Mr. Williams' behalf.
Okay. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
I do.
Okay. Can you state your name and spell your last name?
Josh Brasso, Brasso.
Okay.
Dana Docklin, Doklean.
Okay. Now, usually when the officers come, they say they want the maximum bond. But other than that, do you have anything to add?
No, just the maximum bond in fear he's a threat to the neighborhood, being on house arrest for a armed felony delivery in a prior and committing these offenses with a stolen gun and continuing to deal drugs and trafficking them out.
Okay. Thank you. I am going to, based on the allegations in the probable cause affidavit, based on the prior, and doing this while he's on house arrest, I'm going to set bond on count 1, $10,000. Count 2, $10,000. Counts 3 through 8 will be an ROR. I agree with counsel with respect to each bullet. 9 through 12 will be ROR. count 13 and 14, they'll be 10,000 apiece. The trafficking heroin will be 100,000. The possession of amphetamine will be 1,000. Resisting without violence will be 100. And the probation violations of no bond hold.
Your Honor, would a Nebia hold be possible based on
In the division, they could.
We'd be objecting as far as that request being made by the officer. I believe that's a legal request. I don't think he should be practicing law at this time.
Okay. He's allowed to ask, and that's fine. But in the division, they can do what the division wants to do. Okay? I'm not doing a Nebia hold. You don't have to shake your head.
Thank you.
Joan Vieira. Good luck. Thank you.
Oh, Judge, one request, Mr. Williams. Could we have a photo order?
Yes.
So we can photograph his
If
injuries?
your counsel draws it up, I'll sign it. Thank you, sir.
Thank you.
Sorry, Hector, what did you want?
Photo order.
On Mr.
Williams.
On Mr. Williams, okay.
Thank you.
Joan Vieira. Okay, Mr. Vieira, you have a capias, counts 1 through 8. They're all no bond holds. And you have a status in a division on June 22nd, 1:30. Good luck. David Muringer. Sir, you have a violation of community control with a no bond hold in count 1 and 2. They're both set for, or one at least, is set for June 20th, 2017.
Judge, I'm sorry.
And it's at 9 a.m.
9 a.m. Judge, just one request. Well, I know he's being held in no bond. While he's in custody here with Broward Sheriff's Office here in custody, would you consider signing an order allowing him to enter the life skills program?
Yes.
Thank you, Judge. Thanks, Judge.
Thank you. Malcolm Strawn, S-T-R-A-G-H-N.
Mr. Strong? Mr. Strong, come on up, please.
Okay, sir, you have a violation of probation in count 3, which is a felony, no bond hold, set for June 20th, 2017. You have in count 2 a probation violation of community control, no bond hold. In count 1 is an aggravated assault with a deadly weapon without intent. Did you have an argument for a bond on that?
Your Honor, the state would ask for a $10,000 bond since he is on probation for an aggravated assault, and he has now picked up, this other aggravated assault, Your Honor.
Okay, defense, did you have an argument?
No argument with PC as far as I know he's right now unemployed. He's looking for work. He was working at a funeral home approximately 1 week ago. He was transporting. That was his job description. He made only $9 an hour. He lives in Pompano Beach. He's been residing at the same location for 2.5 years. He rents a room, and his rent is about $400 per month. Judge, we'd be asking you at this time to consider a $2,500 bond on count 1, Judge.
Okay, does he have any priors?
He does, Your Honor, and I misspoke. He was actually on probation for felony battery, so I apologize for that. The prior history.
Yes, Your Honor. He had a. Out of Delray, he had a possession of cocaine resisting without violence with a domestic violence battery. Out of Delray, 2007 conviction. Another domestic violence battery, 2007, out of Lantana. Criminal mischief with resisting without violence. Another battery, 2006 conviction, withheld. Possession of cocaine and drug paraphernalia, 2006. Possession of cocaine out of Palm Beach conviction. A battery, 2004, out of Delray. A burglary in 2003 out of Palm Beach.
Okay, I find since he has a number of priors, danger to the community, I'll set bond at $10,000. Thank you very much.
And Your Honor, no contact with the victim, if you could order.
No victim contact also. Thank you. James Gooch. Okay, Mr. Gooch, you've been charged with grand theft, and you have an out-of-county hold, which is a felony. The bond on that is $4,000, and on the grand theft, the convenience bond is $1,000. State, did you want more or less?
Does he have any other prior history? That's fine, Your Honor.
And defense?
Judge, he has an out-of-county hold. At this time, we're not requesting anything.
Okay, I'll set bond at $1,000 on count 1 and $4,000 count 2. DeMonte Kelly.
Mr. Kelly's approaching, Judge.
Okay, Mr. Kelly, I see you are charged with an operating without a valid license. 2, attaching a registration license plate not assigned. Count 3 is reckless driving. Count 4 is a $250 capias. Count 5 is a $250 capias. Count 6 is a no bond hold on probation violation community control. So he has one hearing on June 26th at 2 p.m. and the felony violation is June 20th at 9 p.m. I'm going to set bond at count 1 at $500, ROR counts 2, and count 6 is a no bond hold. Okay, the other is 100. The capias is or with it. Anything to say? I can't hear you.
Nothing else, Judge.
Okay, thank you. Derek Thomas. Derek Thomas? Anybody know where he... Okay, Mr. Thomas, you've been charged with grand theft, possession of cannabis, possession of cocaine, possession of a controlled substance. Did you have anything against the convenience bond on that?
No, Your Honor.
Defense?
Nothing to add at this time, Judge.
Okay, count 1 is $1,000, count 2 is 100, count 3 is 1,000, count 4 is 1,000. Thank you. Good luck to you, sir. Boris Howard.
Mr. Howard, sir, present?
Yes, you are charged with a violation of probation. You have a no bond hold, and the hearing set on June 20th, 8:30. Good luck to you. Shawakat Mosaic. Sorry if I mispronounced it. Sir, you've been charged with aggravated assault with a deadly weapon without intent, and count 2, carrying a concealed firearm. State, did you have a recommendation?
Your Honor, the state would ask for $5,000 and no contact with the victim.
I'd count 1.
Yes, Your Honor.
Okay.
And count 2 on the standard bond.
Okay. Counsel?
Judge, I'm speaking with Mr. Mosaic. He's been residing in South Florida in our community for 15 years now. He is 38 years old. He currently is employed. He works at a smoke shop. He's been working there for about 4 years. His weekly average income is about $500 per week. He lives in Sunrise. He lives with his wife and son. They've been residing in the same apartment for about 5 years now. Their monthly rent is about $1,100 a month. His wife, Judge, is legally blind. She's a stay-at-home wife. They have an 11-year-old son. So financially, she doesn't work or anything like that. She relies on Mr. Mosaic to pay for all the bills and stuff like that. What we'd be asking, and if the state can confirm, he informed me that this is his first exposure to the criminal justice system, and he is a registered voter here in Broward County. Considering his lack of any priors, his strong ties to the community, his lack of financial resources, Judge, we'd be asking you to consider a $1,500 bond on count 1, Judge, and leave the standard bond in place on count 2.
Also, as to count 2, Judge, I don't see probable cause for carrying a concealed firearm in this probable cause affidavit. If anything, it seems like it was very unconcealed.
Okay. State.
Your Honor, in regards to the defendant not having any prior history, I did not see any prior history. As far as that count, the state would be asking that based on the nature of the charge with the firearm. And if you just give me one moment, Your Honor, I can respond to the probable cause argument.
And what did you say you were requesting in the bond?
$5,000 on count one, Your Honor, and $1,000 on count two, the standard bond. And Your Honor, I believe that the carrying the concealed firearm, I mean, he was carrying it on his person, and then displayed it. So I mean, I believe that that is the concealed manner. I mean, he came up to the victim's passenger side and then displayed the firearm to him. So, I mean, prior to that, it had to have been on his person somewhere.
Well, I guess that pretty much establishes that there's no probable cause for that count, since the state's argument is, well, let's assume that at one point in time it might have been concealed somewhere on his person. But that's not in the four corners of the probable cause affidavit.
Can you look at the statute on Florida statutes?
Okay, you know what? I'll let them perfect it. I'll give them 24 hours. I'm going to set bond at count one. I do find probable cause. That will be $5,000.
And Your Honor, could I get 48 hours to perfect on count two?
I'll give you 48 hours.
Okay.
Judge, I'd object. If they can't perfect it within 24, I mean, I don't even know how they can perfect it anyway, quite honestly.
Well, I don't think it will be hard to perfect, actually, so I'm going to let them have it. Thank you. John Frederick Dunn. Mr. Dunn,
Yes.
driving with your license suspended. I find probable cause. State, do you have any objection to the convenience bond?
No, Your Honor.
Defense, do you? Or you're looking for less?
Judge, I know Mr. Dunn, he has priors. He's just asking, Judge, if you could reduce it to $500.
Any objection?
No objection.
Granted.
Good luck, sir. Thanks.
Julius Hall.
I think he's in North Broward, Judge.
I'm sorry, I didn't hear that. Yes. Okay, you're charged with violating a municipal ordinance, and you have a warrant with a no bond hold on the violation of pretrial felony. So I'll just set the municipal ordinance bond at $25. Okay, good luck to you, sir.
Yes, sir.
And I do find probable cause. Marquise Thomas.
Mr. Thomas, come on up, please. No. Mr. Thomas, you're present judge at Maine.
Marquise Thomas, yes, you have been charged with robbery, firearm, and carjacking with a firearm or weapon. State, what are you looking for?
Your Honor, Christina Pineda on behalf of the state, Your Honor. Both counts are punishable by life felonies, Your Honor. So the state would be asking for no bond on both counts. Additionally,
Judge, I haven't seen the probable cause affidavit in the case. I'll need to review that before any determination as to what an appropriate bond of the case might be.
Okay, well, I will tell you I did read it, and I do.
But I can't make a legal argument against it until I've read it. Now, if you want to reset this to 1:30 to give me a chance to do it, I don't have a problem with that. But I will need the state to provide me with that paperwork.
Or we can print out a copy.
Yeah, that'd be great. You can print me out a copy. That'd be fine.
We don't have to. We'll put them at the end, and
We can put them at the end.
Ed's supposed to setting them for 1:30.
Okay, that's fine.
And I just want you to know there was an admission in the
Yes.
probable cause affidavit.
Yeah, just that.
Jacob Baker.
Mr. Baker, come on up, please. He's approaching, Judge.
I see him.
Oh.
Okay, you've been charged with possession of cocaine, probation violation of or community control with a no bond hold, another count of probation violation, community control, with a no bond hold, and you have an out-of-county hold with a no bond hold. State, did you have any objection to the $1,000 bond?
No, Your Honor.
Defense?
Nothing to add, considering.
Okay, I do find probable cause. I'll set bond on count one at 1,000. The others are no bond holds. Good luck to you, sir. Derek Smith.
I've been informed Mr. Derek Smith bonded, Judge.
Okay, good. Philip Villanueva.
North Broward.
Okay, sir. Good morning, sir. You've been charged with, you have a violation of probation with a no bond hold. It's set for June 20th at 8:30 a.m. Good luck to you.
Is there any way I can request a bond so I can keep my job?
No, because you have a violation of felony probation, but they do have it set for hearing on June 20th.
Okay, thank you, Your Honor.
Thank you.
You have a good one.
Cordall Thompson.
Mr. Thompson, you're present, Judge, in Maine.
You have been charged with a possession of cocaine. You have been charged with a possession of cocaine 20 grams or less and driving with your license suspended. State, are you just looking for the convenience bond?
Yes, Your Honor.
Defense?
Judge, Mr. Thompson advised me that he lives in Fort Lauderdale, an apartment with his girlfriend. He advised me that he was interviewed by pretrial. He liked what they had to say, and he wants very much for Your Honor to try and see if you can impose standard pretrial on his behalf.
Any objection?
He liked very much what we had to say.
Yes.
This is Mr. Thompson. It does appear that he has a warrant, Your Honor, out of Dade County. So as much as he may have liked what was said, we're not making a recommendation.
Okay, did you hear what she had to say?
Yes, Judge.
Okay. Do you want to revise your defense?
Judge, the only thing then we would ask you to do is would you sign a phone order?
Okay, I'll set bond at, I'll find probable cause. I'll set bond at $1,000, count one. Counts 2 and 3, I'll ROR. I will sign the order allowing him to look at his phone if Mr. Reedy has time to prepare it.
I will prepare that immediately, Judge. Also, we can go back to Mr. Marquise Thomas if you want to.
Do you want to?
I'd like to.
Okay. That'd be great. Did you have an argument on probable cause?
I do.
Or proof evident, presumption great?
Yes, Judge, if Mr. Thomas could come forward. Marquise Thomas, right behind you there, Hector.
Yes.
Judge, this is a bare bones probable cause affidavit, barely even indicating anything. There's not even any statements from the victim. All it does is rely on an alleged statement by Mr. Thomas. The state is asking you to hold Mr. Thomas without bond, which is the most severe pretrial detention sanction available. And in order to do so, this court would have to make a finding that the proof of guilt is great and the presumption is evident. This is a one-paragraph probable cause affidavit which just says that Mr. Thomas admitted to it. Now, the state hasn't even provided the court with a transcript of this statement. They've introduced no evidence. They've called no witnesses. There's not even an indication as to what the victim has to say or what type of identification was made or anything like that. I would say that based on this probable cause affidavit and based on the Florida Constitution, based on State v. Arthur, based on the recent decision from the 4th District Court of Appeal of Omar Yaza versus the State of Florida, YSAZA 4D170612, that this court has to make a finding that the proof is evident presumption is great. I just don't see it in this probable cause affidavit, Judge. There's just really nothing here than an allegation that he confessed. We don't know the circumstances of that confession. We don't know how long he was detained before he made this statement. There's absolutely nothing here. And I understand the state wants to come back with something more later on, but at least as far as this hearing today is concerned, this is not proof evident presumption great, which is the highest standard we have in criminal law. It's higher than proof beyond a reasonable doubt. This is a not guilty verdict staring us right in the face. If this is all they've got nothing. In fact, you go ahead, Hector.
The only additional information I'd like to share with the court is my understanding is Mr. Thomas is 16 years old. He's in 8th grade. There's been countless studies as far as age, level of education, how much it plays into account as far as false admissions. And if what I heard is correct, the basis of the whole state's evidence against Mr. Thomas is his own admission. We don't know the context, what he actually said, how long he was questioned for. We don't have any of that. It's void from what I've been hearing in the probable cause affidavit. So in order to reach that level of proof evident presumption great and just relying on an admission with nothing more, I agree with my colleague.
And I would even point out, Judge, that there's nothing in this probable cause affidavit that even indicates the victim was robbed other than Mr. Thomas's statement. I don't even know if they spoke to the victim.
Your Honor, if the state may be heard, I do have additional information if Your Honor would like to consider it. It's a sworn statement of the victim. I'd be happy to provide it to defense counsel as well. As it is a sworn statement, I believe that you can consider it in making a probable cause determination with a recorded statement of the victim if you would like more information regarding the charge.
I'm not going to look at it until you show it to defense counsel.
Of course. Here, why don't you give him that copy and we'll print another one.
Okay, let's get back to Mr. Thomas in a little bit.
I thought we were ready to do it, Judge, but I guess not.
Okay. We'll go back to Edward Baker. Mr. Baker, you are charged with counterfeit, falsely made credit card. You have a capias with a $500 bond on it, and another count of counterfeit, falsely made credit card. You have a division hearing, status hearing on June 26th at June 26th at 11 a.m. State, are you looking just for the convenience bond?
I apologize, Your Honor. This is Mr. Baker that we are addressing. I just want to see if he had... Just one moment. I just wanted to double check the prior history.
And I do find probable cause. Were you looking for anything in particular?
Yeah, Mr. Baker said he was interviewed by pretrial, and based on that interview, he wishes to see if the court would impose pretrial release on him.
Pretrial, is he available?
Edward Baker?
Yes.
Your Honor, we were unable to make a verification on Mr. Baker's behalf. And I also noticed that count 2 is a failure to appear on Mr. Baker. At this time, I'm not making a recommendation on his behalf.
And Your Honor, the state is fine with the standard bond.
Any objection to the standard bond?
Judge, Mr. Baker is still requesting, since his interview with pretrial, he wishes to see if he can be on pretrial, even though they're not recommending. It's within your discretion to impose pretrial.
Okay. I'm more inclined to just set a bond. Does he have family, friends, anyone that could help him?
I can inquire. Judge, what he advised me, he does have members of his family that live in the community. He's going to call them. He believes it's going to be about like a week or so before they can come up with the full $2,500. If Your Honor would be inclined to at least on count 3 ROR, then that would be that much sooner that they can acquire the funds to post his bond.
Any objection?
Count 3 in ROR, Your Honor, the counterfeit. Your Honor, I would object. I believe that the $1,000 bond is appropriate on that count.
Does he have priors?
Yes, Your Honor. There's a DWLS habitual from this year. Possession of cocaine, 2016. 2015, possession with intent to sell or manufacture, deliver PVP, it looks like. And leaving the scene of an accident, 2015. Possession of cannabis withheld. 2003, possession of cannabis withheld.
Okay, based on his priors, I'm going to just keep the convenience bond, 1,000 on count 1, 500 count 2, count 3 is 1,000. Thank you very much. Joshua Tapper. Sir, you've been charged with Possession with intent to sell and deliver cannabis, possession of cannabis over 20 grams, drug paraphernalia possession, tamper with or fabricating physical evidence, and a probation violation of community control, which have a no bond hold. Are we all looking for the standard bond on this?
Judge, I'm going to make a probable cause argument as to the element of possession with intent to deliver. The probable cause affidavit mentions an amount, it mentions baggies, but it doesn't have any real specificity to say that this is anything beyond personal use or that this was something that Mr. Tapper intended to sell. I mean, there's cannabis on the floor. They mentioned baggies. It's not indicated whether these are baggies that are individually packaged, that they might look like they're available to be sold. And 40 grams of cannabis is not really all that much as far as intent to sell is concerned. And there's no even mention of any type of scales or lists of names or cash recovered. This is just a possession of cannabis case, Judge.
Your Honor, I would argue that 40 grams is a large amount of cannabis. I think that amount, coupled with the baggies that were found with the cannabis, would show the intent element there.
Well, how many baggies were found? Was it one baggie with 40 grams? And I disagree with the state that 40 grams is not within the realm of personal use. We don't know how many baggies there were. There one baggie, two baggies, 20 baggies, 40 baggies? We don't know. And there's just not enough here to conclude that this is a possession with intent to deliver.
And Your Honor, if you look at the second page, it does say several baggies, which contained cannabis in them.
Okay. It's not the best written probable cause affidavit. I understand your argument, but I am going to find probable cause.
And I would ask the court to keep the amount set on the bond on that charge proportionate to the weakness of the state's position.
Okay, I will understand that. And did you have any objection to the standard convenience bond? Or?
No, Your Honor.
Okay. I am going to set and does he have priors?
Well, Your Honor, this is a violation of his probation, which he was
Well, he has a no bond hold on it.
Correct,
so.
for trafficking in cocaine. And then he does have priors. In 2012, he had a possession with intent to sell, Your Honor. In 2010, driving under the influence.
Another 2009, I highly have another.
Oh, I'm sorry.
Another driving under the influence, and the priors, Your Honor.
Okay. I'm going to reduce count 1 to 4,000. Count 2 is 1,000. Count 3 is 100. Count 4 is 1,000. Count 5 is the no bond hold. I find probable cause. Thank you very much. Good luck to you, sir. Corinthian McCrae.
Mr. McCrae's approaching, Judge. He declined the service of public defender.
Okay, sir. I do find probable cause. You were charged with a robbery by sudden snatching without a firearm or weapon. State, did you have a recommendation?
Yes, Your Honor. The state's offer was a $10,000 bond, Your Honor.
Does he have priors?
Your Honor, he does not have prior history.
Okay. Sir, do you have a job?
Yes.
What do you do for a living?
I work at the Wild Factory. It's like a Chuck E. Cheese place.
Okay. And how long have you worked there?
Since last October.
Okay. Do you have family or friends who can help you pay a bond?
Yes, sir.
Okay. The state is requesting a bond of $10,000. Can they help you with that?
That's a lot, but I can see.
Okay. And you wanted to decline the services of the public defender? You didn't want them to try to help you?
I really didn't know, like, you know, what all that meant. But
Okay. Judge Siegel did a no bond hold for this, but I can set a bond, correct? Yeah. Okay. Based on the probable cause affidavit, I'll set bond at $7,500. Thank you. Good luck to you. And no victim contact. Tyrone Hayward. Mr. Hayward, you were charged with a violation of felony probation with a no bond hold. You do have a hearing date, June 20th, 9 a.m. Good luck to you. David Brown. You were charged with a robbery with a weapon. State, did you have a recommendation, and are there priors?
Your Honor, I'm pulling up the priors right now, but the state's recommendation is $50,000. He has an escape charge out of Orange County in which he was convicted, Your Honor. And that was in 2004, Your Honor. He also has an unlawful discharge of a firearm, which he was adjudicated on in 2008. He has possession of carrying concealed weapon charge he was adjudicated, and in 2000, and as well as the petty theft that he was adjudicated on.
Okay, counsel, did you have an argument?
Judge, in speaking with Mr. Brown, he is 45 years old. He's currently employed. He works in the construction business. He's been doing that for about 10 years now. He gets paid per day, about $80 per day. He has no money in the bank, no property. He lives in Miramar with his sister. They've been residing in the same home for over about 4 years. His sister is the one who actually, pays the rent on the place. His sister is employed. She takes care of senior citizens. She does get paid a nominal wage, considering, and that's the person who he's going to contact to help post his bond. What we'd be asking you to do is the $50,000 bond is going to be too excessive for Mr. Brown and any of his family to post bond. We'd be asking you to consider setting a bond of $5,000 on Mr. Brown's behalf, Judge.
Okay. Okay, I am going to set bond based on his priors. I consider him to be a danger to the community and a flight risk, and I'm going to set bond at $25,000.
Yes, Judge.
Okay, Patrick Mussington.
I've been informed he bonded, Judge.
Nicholas Goldsmith.
Mr. Goldsmith, come on up, please.
how you doing?
Good, how are you?
Good.
Thanks for asking. You were charged with loitering or prowling, and you have a felony warrant with a no bond hold. I'll set bond for the loitering at $25. I do find probable cause. Good luck to you, sir. Robert Anthony.
Mr. Anthony.
Sir, you've been charged with burglary of an unoccupied dwelling. I find probable cause. State, do you have a recommendation?
Your Honor, he does have prior history. In 2009, he had a burglary of a conveyance that he was convicted on. In 2009, he also had a burglary of in 2011, he had possession of cocaine, which he was convicted on. As well as tampering and destroying evidence, which he was convicted on. In 2011, another possession of paraphernalia and a possession of cocaine that he was convicted on. and in 2012, possession of cocaine with intent to sell and delivery, which he was convicted on.
What's your recommendation?
My recommendation, Your Honor, would be $15,000.
Defense?
Judge, Mr. Anthony's been residing in South Florida his whole life. At this time, he's unemployed. He is looking for work. He lives in Fort Lauderdale. He lives in an apartment with his mother. He has no money in bank, no property. From what he advised me, his mom will be helping him post his bond, but she's retired, so she's on a fixed income. We'd be asking you to consider a $2,000 bond on Mr. Anthony's behalf.
Okay, I'll set, based on his priors, I consider him to be a danger to the community. And based on the nature of the offense, I'll set bond at $5,000. Thank you. Christopher Snell. This was a reset.
He's in Conte, Your Honor.
Okay, I find probable cause on counts 4, 5, and 6. Are you looking for the standard bond?
Yes, Your Honor.
Defense?
Is the standard bond for a third-degree felony of burglary of an unoccupied conveyance $7,500?
That's what it's saying, yeah.
I think that's rather excessive, Judge, based on the nature of that charge. I'd ask for a $1,000 bond on that.
Any objection, State?
I want to see, this is count 4, so I just wanted to see what.
These are ad charges, Your Honor.
He has a $15,000 bond already on count 1.
Yeah, I understand. That's why I'm asking. I'm
Right.
not disagreeing with you. I'm just asking for their opinion.
No, I understand.
Your Honor, based on the fact that this is an ad charge, I would like the bonds just to remain the standard bonds as set.
And what were you requesting, Mr. Reedy?
I think $1,000 on count 4, Judge, is proportionate to the allegation. Did you want to say something, Christopher, without talking about the facts of your case?
Yes, I would, please. I'm currently ordered to go to Broward Addiction and Recovery Center, and I can't be released to that program. It's a residential program. I can't be released until bonds are paid, and my family just cannot afford that type of bond. And I would like to get my recovery, started, if at all possible. I don't know what kind of other options there are.
Well, I don't know that the court would be inclined to release you on your own recognizance, Christopher. I think maybe we start by getting a low a bond as we possibly can, and I'll get you in front of your division judge as soon as possible. That judge could ROR you and let you go to the program. I'll try and get that done for you next week.
All right, maybe
Okay.
a monitor even, no?
Anything I do today is not going to change your circumstance because you can't afford the bond you already have. I understand that.
Well, I can afford some bond on this matter here, but the $15,000 one is an issue as well. So
That's not even before the court this morning, though.
Yeah, I can't do anything on the $15,000, so this becomes just on top of that. I'm going to set bond on count 4 at $3,500, and count 2 is the $750, and count 3 is $1,000.
4, 5, and 6.
You mean 5 and 6, Judge?
I'm sorry, 5 and 6. Yes. You know what I meant.
I know what you meant.
Thank you.
Just
Good
so the
luck
record
to you.
does what
I
you
wish
meant.
you luck.
All right, Chris, I'm going to try and get you in front of your division judge next week if I can to get you out of here, okay?
know who that division judge is, sir?
I don't yet, but I'll find out.
All right, thank you.
Lawton Gillard.
He's on loan still?
On medical loan, I believe, Judge.
So just reset?
Yes, please.
And Jackson.
And then we have Quentin Jackson.
North Broward.
Medical reset.
Medical reset.
Yep, I got it right.
And then we have Malik
Benamy, it's your president judge at Maine.
Malik Benami. Okay. He has a felony, capious, hold,
Is this a change of charge, right?
and he has attempted murder.
And Your Honor,
Is this the one? This is the one.
you probably just have to do it by his last name.
No, I don't have anything on this.
do it that way.
Your Honor, I will pull it up for you, and as well as for the defense counsel. I believe that this case had actually come before a judge previously at magistrate court, and he had been booked in on murder, but at that time the judge found PC for attempt, so this was just something that the clerks did as a change of charge. I'm going to pull up the PC as well as the judge's findings for both you and the defense counsel.
Okay. Then can we have a seat, sir? We'll come back to you in a
Go to
little bit.
file management.
Joseph Baker.
Pull up the PC.
Mr. Baker's here present, Judge?
That's the perfection. That's right there. You're on.
No. This one, because that's the one from the actual. Just print 2 copies, please.
Okay, it's a perfection. Counsel?
Action as to count 1, Judge.
Okay, perfect.
Yeah. And
so I don't know what else the state has.
Did you get the perfection?
Is that what this is?
Yes.
Because it doesn't have Mr. Baker's name on it.
Your Honor, I believe it does have the same case number, and that would correspond with the case number of the original.
Yeah, but that's why I didn't connect the two. This is Detectives Smith and Smith, this one?
Yes.
Okay.
Yes. And do you need a copy of the original PC?
No, I have it right here.
Okay.
Okay.
So count 1 was trafficking in heroin, and the issue was
they field tested it.
It was field testing it. Okay.
And that's in the document.
All right.
So I'm going to find probable
I see the amended information, Judge.
I'm going to find probable cause. So now we're on the issue of the bond.
Correct, Judge. And seeing Mr. Baker, he's 60 years old. He's been residing here his whole life, Judge. Unfortunately, at this time, he's not working. He's on disability. He has a severe injury that and his leg. He gets approximately $860 per month on disability. He has his brother who resides in our community. That's who he's going to potentially call to help post his bond. But $200,000 is out of Mr. Baker's reach. As for including his family, they cannot possibly come up with that sort of bond amount. Judge, what we'd be asking you to consider at this time is reducing the bond from $250,000 to $25,000 on count 1, Judge.
Okay, State, do you have any objection to that?
Your Honor, I would like the bond to remain as the bond that was set of $250,000 on count 1, Your Honor.
Does he have any priors?
I am pulling that up right now. It is 60542. 428. I'm looking at, this is what I have from Broward County, Your Honor. From 2013, he had a possession of cocaine, which he pled to and was sentenced to state prison. In 2006, he had a possession of heroin, which he pled to and was sentenced to state prison. In 2003, he had a possession of cocaine, which he pled to, also sentenced to state prison. In 1984, Your Honor, he had a battery on a Leo, sentenced to state prison in 1984. Your Honor, he had a second-degree murder in which he was sentenced to state prison. And that is from Broward County, Your Honor. I don't know if there's anything outside of pretrial. Would you mind confirming? Do you know if he has anything outside of Broward?
Judge, I believe he's also in custody on other counts, which he was magistrated on yesterday.
Okay. Based on his priors and the nature of this crime, I'm going to find him to be a danger to the community. I'll set bond at $250,000. Count 2 will be $2,500. Thank you. Okay, getting back to Mr. Bien Ami. It was a charge for attempted murder. I would find probable cause. based on the affidavit. So, what are you requesting?
Your Honor, I would request, it looks like previously on the premeditated murder, the judge had held him no bond and the other counts remained at $15,000. I would just ask that that remain the same, based on.
This is on count 1.
Yes, Your Honor, count 1, I would request, based on the seriousness of the charge, as it's a punishable by life felony, that he be held no bond. And like, as I had mentioned previously, a judge at first appearance had found probable cause for premeditated murder and had
Well,
found
I
a no
think I
bond.
have to find more than that.
I haven't seen the probable
had
cause
found proof as
affidavit or the
evidence.
police report in this case.
I thought they just gave it. I thought they gave it to you when they gave it to me.
Oh, that's what that was. Oh, okay.
And Your-
All right.
And I'm sorry, Your Honor, I believe that the judge had found proof evident presumption grade as to hold him pre-bond or no bond on the attempted murder, Your Honor. Looking at the notes, if you see from the booking sheet from that day.
If I could have just a moment, Judge.
And were you going to show me something on Mr. Thomas?
Yes, I believe Ms. Panetta gave it to you.
No, I need to.
You didn't give that to me, did you?
No, none.
Okay.
Sorry, a lot of papers, I don't.
Yep.
For a moment, I thought I was going to give it with the other papers, but. Right, that's right. I remember
Okay. Are you ready?
Yes, sir.
I'm Mr. Benamy.
Yes, Judge, I would agree that there is enough here for the court to establish probable cause, but it is not enough for proof evident presumption great. There's allegations that one of the victims knew Mr. Ben-Amin, but there are no photographs produced by the state. There's been no evidence introduced by the state. There have been no witnesses called by the state. The state is relying solely on a police report, and that is not enough to establish proof evident presumption great under the Florida Constitution, under State v. Arthur, or any of the other applicable case law, including the State versus Yaza, or Yaza v. State, YSAZA, a recent 4th District Court of Appeal case for D170612, that this is not enough to establish probable cause. So we would ask the court to conduct an ARPA hearing at this time, and based on the evidence submitted by the state, ask the court not to find proof evident presumption great, which is the highest standard in criminal law, and to set a bond for this gentleman.
Okay. Mr. Ben-Amin is charged with attempted murder. I have reviewed the probable cause affidavit filed in the case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, you're to be held without bond until further order of the court. The order is without prejudice for the defendant to file a motion to set bond with the assigned division judge and request a hearing under State v. Arthur. Thank you very much.
Yes, sir.
Okay, did we want to go back to Thomas, or did you want to
Yes, we can do that.
do something else? I think it's the last case.
I don't think we have anything else to do, quite frankly.
No.
Judge, well, one thing I did forget, on Joseph Baker, that was the previous gentleman, I forgot to request a phone order on his behalf.
I'll grant
I told
that.
him I would.
No worry.
Thank you.
I got it. I got it. Yeah,
Thank you.
yeah.
I won't leave till I sign it.
All right, you owe me a cup of coffee.
He's the last gentleman. I think we're waiting on him.
We can hear you, brother.
Oh, we have one last case, right?
Yes, Mr. Thomas.
Mr. Thomas.
And we have the issue of the state requesting proof evident presumption great. And we have Mr. Reedy arguing against it.
I am, Judge. I've been provided with a transcript of the statement of the alleged victim in the case, Ms. Hunter. I've reviewed that statement, and this still does not establish proof evident presumption great. I'd direct the court's attention to page 10 of that transcript, and we're talking about the photographic lineup that Ms. Hunter viewed in an extremely, it seems to me, extremely suggestive setting. The detective asks on page 10 of the 12-12 transcript at the top of the page, and this is the guy that you believe took your car. Answer, I think so, yes. That's far from any kind of a positive identification, Judge, and certainly far from establishing proof evident presumption great. And then we have this extremely suggestive question from the detective next. And what you remembered from that picture is his face. And the witness says, uh-huh. Followed by this extremely suggestive question. 'Cause his head was covered. Answer, yes. And then the most suggestive question of all asked by the detective, extremely improper technique, horrible form. Question, so you got a good look at him? Answer, uh-huh. And then he says, okay, yes? Yes, did you get a good look at him? Oh, yes, I did. Oh, yes, I did. The guy's head was covered with a hood. You didn't get a look at this person. I'd love to cross-examine this detective based on this statement if I had him on the witness stand. Unfortunately, the state decided not to call him. Maybe that was a good decision on their part. But based on this, the age and relative immaturity of Mr. Thomas at a young age of 16, we don't know any circumstances about the interrogation that was conducted of Mr. Thomas. Certainly, if this detective used the same interrogative techniques with Mr. Thomas that he used with the victim in the case, this entire statement by Mr. Thomas, which we don't have a transcript of, that has not been provided, is also very suspect. Who knows what kind of leading and forceful questions the detective asked Mr. Thomas when he had him alone in a room. So this is not proof evident presumption great, Judge. I'm going to ask you to set a bond for Mr. Thomas.
If I may direct also to page 3 of it, the detective does ask where the shirt is located and says it's over his head, yes. asked if it was on his face, to which the victim says, no, it was not on his face, it was just on his head, thus showing that the victim did get a chance to see his face and going towards the valid identification of the defendant. Furthermore, Your Honor, on the identification, if you do go to page 9, which is before the questioning, the line of questioning and answers, defense counsel pointed out, does show that there were a series of pictures that were presented to the victim, to which the victim was able to identify. It says here, you identified, and confirming if it was the photo that the detective must have had in his hand at that point, and asked to confirm if that's the person that she believed, and you can see there that she did circle. So going towards identification, Your Honor, the victim was able to identify, was shown a series of photos to which she pointed out the defendant, and was able to see his face, seeing that the shirt was not covering his actual face. Furthermore, Your Honor, so for identification, that's it. That I do believe that there is a valid identification. And then, as per the statement, there was a gun used. The victim was able to see the gun. The defendant had it ready in his hand, and she was able to see it. He also pushed against her, and during that interaction, he ended up taking some of her belongings, including a phone, a purse. After that, got in her car and drove away. Again, all of this after using a weapon and a gun and a firearm here. So I would say that there is, that we have proof evident and presumption great, Your Honor, as to count 1, robbery of a firearm, where per the statute, we would have to prove that there was a firearm used in the course of a robbery. In this case, Your Honor, a firearm was used by the defendant in taking the victim's items. Furthermore, that's looking at statute 812.13. Furthermore, looking at carjacking with fire or weapon. Again, Your Honor, a firearm was used, and then after that, the defendant took her vehicle. So I do believe that the state has proved that there is proof evident and presumption great, Your Honor. So that's what the state would
If I may just briefly, Judge, in directing the court's attention to this series of questions on page 9, again, the same technique is used. The detective is the one testifying, not the witness. You particularly identified one, is that correct? Uh-huh. And you circled his face, right? You signed it. Uh-huh. Put a date on it. Uh-huh. And then she says, and you believe that's the guy who took your car? Her answer is, I think so. That is not a positive identification. The most common area where innocent people are sent to prison is misidentification. And this is, I think so. That's not proof evident beyond a reasonable doubt. And if the state was serious about asking this court to impose the most serious pretrial detention sanction available, and they have a confession from Mr. Thomas, but we don't have that transcript, instead we have the victim's transcript, this is what they should present to the court.
Level, we don't usually have transcripts of depots.
I understand that, but they're claiming Mr. Thomas confessed. Well, isn't that the evidence that you would think they would present to this court when asking Mr. Thomas to be held without bond? And they haven't done it.
Not at this point, but anyway, state.
I was just going to say, Your Honor, I did ask for it, but I believe it's on an audio disc, so I wasn't sure how I would be able to bring any of that. I mean, if that's something that we really, you feel like you need, I can try to do what I can.
This is what I'm going to do. Going to find proof evident, presumption great. The defendant, Mr. Thomas, is charged with robbery with a firearm. I have reviewed the probable cause affidavit in the case. I find probable cause. I further find proof of guilt to be evident, or the presumption great. Therefore, you're to be held without bond until further order of the court. The order is without prejudice for the defendant to file a motion to set a bond with the assigned division judge and request a hearing under State v. Arthur. I don't consider this to be the Arthur hearing, and so I don't need to go through everything other than the probable cause affidavit. the defense raised an issue with respect to the victim. We heard that. Okay, thank you.
I apologize, Your Honor. And then no victim contact and no weapons or.
Okay, it'll be hard to have victim contact from the jail, but
Correct. Just to
I'll do that. Thank you. Have a good day.
Judge, I just have this.
One final question. Do you know this afternoon what time we're going to be starting at 1 o'clock?
I'm going to come back to the courtroom at 1.
1. Okay, so we'll start at 1 o'clock.
I didn't say that. I said I'm coming back to the courtroom at 1.
Okay.
Thank you.
Thank you.
You could tell him I do intend to start as soon as possible.
Judge, can I just hand it to you? This is the.
Yes. Just so you know, we're online. I can't turn this off.
Yeah.